Thank you to all the witnesses. Let me just open where we concluded there, Professor Campbell. You testified that there's a different liability standard, different approach for brick and mortar stores versus online platforms. Mr. Shears concluded by saying we should have one approach, one common approach to how we regulate commerce, online, large, small, brick and mortar. Help me understand. Square that circle for me. Doesn't ShopSafe try to apply a similar liability standard online as already exists in brick and mortar, or do I misunderstand?
So in my opinion, it does attempt to do a similar contributory liability in the e-commerce space. So in the brick and mortar space, and we've seen that through several cases starting back in 1992 with Hard Rock versus Concession Services before the Seventh Circuit, that people who were running flea markets or landlords, they were considered service providers. They were responsible for reasonably looking around their property to determine if counterfeiting was taking place or other activities. So what happened with the Tiffany versus eBay case, and a few other cases too, is the court decided at that time, which again is about 13 years ago, that it was unreasonable for an e-commerce platform to be able to look through their own platform to find these postings. And I think we've seen through the changes in technology, particularly AI and machine learning, that has shifted. And it's no longer unreasonable for a platform to be able to see what's on its own platform, but also to vet proactively sellers and those postings and the images that are going up to make sure once something's posted is actually safe for the consumer to purchase.
Mr. Lamar, one of the things that ShopSafe would do, one of the attempts at definitions for sort of best practices to define a safe harbor would be to have a standardized set of, if you do these things, you would avoid any contributory liability. Your members sell their products on all different platforms, all different sizes. You have small, medium, and very large companies selling on platforms of all different sizes. Each of these platforms have different rules, different programs, different approaches to addressing counterfeiting, some laudable and very sophisticated, engaged, some virtually not at all. Would it benefit brand owners to have a standardized menu that says, this is the kind of cooperation you need to provide to platforms?
Yeah, I think you hit the nail on the head, Senator. There is a lack of consistency about what exists. We've actually created tools to kind of tell people, our members, when you go to this platform, here are the things you can experience. When you go to this platform, here are the things you can experience. And it would be much better if there were a very clear, simple federal guidelines. If you want to do business in this country, here's the way you need to approach the U.S. consumer. And create that very common sense set of proactive. Right now it is reactive, it is after the fact, and it is inconsistent. So something that actually creates a very common central approach is exactly what we need.
Mr. Shears, you said ShopSafe, you have a number of criticisms of it. One is that it puts no new obligations on brands. What would you suggest as, in your view, one of the most important things we could do to achieve a better balance of responsibilities and liabilities online?
So thanks for that. Thanks for that. The bill as it stands indicates that information sharing should occur, but then states that it's not necessary, effectively, if information about trademarks is publicly available online, which is effectively every trademark by virtue of the fact that all of this information is available through the Patent and Trademark Office website. So the statute as it presently stands creates a null set. It regulates 0 companies. What we would want to see is an obligation on brand owners to share more granular information about products and provide information about, for example, new products being introduced, imagery that they have that's legitimate, and whether or not that's been licensed. But it's important to sort of step back and recognize that the Trademark Act currently defines counterfeit as products. It requires a definition that is whether or not the product has been manufactured under license, and that is information that only the brand owner has. And so having availability to that information would go a long way towards allowing e-commerce platforms to implement the kinds of sort of takedown requests that they're getting.
Thank you, Mr. Shears. Mr. Shapiro, uniquely, you sit sort of in the middle of all this, mediating oceans of data going back and forth between brands and platforms. I think you said 35 million incidents a year.
A day.
A day, right, a day. So it's only today with modern technology, with AI, with incredibly capable technology that we can begin to examine and process things like whether this image is a trademarked and protected image of the actual product or it is something fake. How would you strike the balance here between putting more obligations on trademark holders, licensors, and putting more obligations on platforms?
Yeah, I think it's a combination. Thank you, Chairman. I think it's a combination of a lot of challenges coming together today. Today in marketplaces around the world, my former company I work with, somewhere I read online recently that there was 1.7 billion listings currently available. Amazon is probably double or triple that. Alibaba is probably adding close to 1 billion items a day at a conference that I was at not too long ago in terms of suggesting that's how many listings. I certainly can't verify about it. That's just what I heard. But at that volume, the ability for brands to monitor that on their own, impossible. Today, unless you deploy some level of technology, you can't get there. And with platforms today, with that many listings on their sites, and with brands having 2 and 3 million SKUs, there are some very big brands with lots of SKUs. There probably isn't one person in the company that knows every product in which they make. And so when we deal with brand protection teams at a particular brand, they're often an IP legal counsel, very sophisticated in the world of IP, but they work for a company with 1 million SKUs. They don't know which items are authentic and which are counterfeit. If they've only been there a year, they might not even know of the product previously that was out there.
Understood. What suggestions might you have for us about how to better balance the obligations of brands and
Yes, so I think to answer your question then, I think that there has to be an investment from the brands to help, right? There's the unwillingness today to share too much information with platforms because there's a lack of trust with the platforms that if they told them their intellectual property, that maybe somehow that would get to a counterfeiter. So if today we could get
In other
brands,
words, if brands are required to get well into the granularity of how to make their product, not just have we registered the
Yes,
trademark, are we making it under license, but exactly all the schematics and the details and the
yes, and that's
there
how
are
we
in
work.
fact actions against some platforms for manufacturing.
Exactly.
competitive.
And that's how we work. They share with us their IP. We use that IP to crawl and find that product. And we keep that. We don't share that with the platform, but we have that, right? So that's the first step of trying to solve this, is a bit more comfortable level of sharing that IP and sort of trusting one another that we could do this together if we think about a good common place on how to do it.
Thank you. I need to yield to my ranking member, Senator Tillis.
Thank you, Mr. Chair. Mr. Chair, I